Described by former Assistant Secretary of the Treasury during the Reagan era, Paul Craig Roberts, as the nation's leading authority on the social politics and social economics of divorce, Professor Baskerville is currently Professor of Government at Patrick Henry College, as well as holding the position of Director of the International Policy and Politics Program. Previously, Professor Stephen Baskerville was Professor of Political Science at Howard University. Professor Baskerville also has a large body of work in the public domain, which includes magazine articles and newspaper pieces, as well as authoring a number of books, one of which is the very highly regarded Taken into Custody, The War Against Fatherhood, Marriage and the Family, Cumberland House Publishing. And the Amazon book review list is linked below. And for those with an interest in this subject of the divorce culture we in the West live in today and have lived in for some time now, along with the wider social ramifications and consequences of such a culture, Professor Baskerville's book is a must-read. So it's 8 p.m. at night, but Professor Baskerville joins TacitusToday, having clambered and shivered across the Virginia snowdrifts to make it to this interview while I sit in sunny Sydney in the land down under, only metres away from a sparkling swimming pool. So introducing Professor Baskerville, let's get to it. Professor Baskerville, could you talk a little bit about your book, your very highly regarded book, Taken into Custody, The War Against Fatherhood, Marriage and the Family?
Well, that was a book I wrote centering on the divorce machinery from a political standpoint. Of course, there's many books, self-help books written by lawyers and by aggrieved litigants on the subject of divorce, but nobody had really analyzed it. Nobody with formal training in political science had ever attempted to explore the politics behind the divorce machinery. And that is kind of the main theme of the book, is that there is an extensive politics. It's not just a matter of therapy or law or psychology, but there are political players behind this, government officials and others, who there's a game of power going on, and pecuniary interests, financial interests as well. And I saw that this explained a lot of the apparent, apparently illogical and what many people felt to be and still feel to be the kind of insane or illogical or bizarre aspects of divorce and family law. And I argued that if you just look at the politics behind it, it's all very logical.
Okay, now you've got a large body of work in the public domain, which includes magazine articles and newspaper pieces. And of course, you've authored a number of books, of which Taken into Custody was one, and that's with Cumberland House Publishing. And I'll put a link below to the Amazon book review. And for those with interest in the subject of divorce culture in the West that we live in, and have lived in for some time now, and the wider social ramifications of such a culture, Professor Baskerville's book, The War Against Fatherhood, Taken into Custody, is a must-read. As I say, I'll leave a link below. Now, Professor Baskerville's joined us here very kindly, having clambered and shivered through the Virginia snowdrifts to make it to this interview. Well, I'm sitting in sunny Sydney, by the way, next to a sparkling swimming pool. So just to get the contrast there. On the politics of how it came to be, quite a few people ask me, how did it come to be so that we have this sort of divorce culture, and sort of moving away from the Hollywood type divorce culture that we saw during the days of Errol Flynn and those sort of things. How did the modern divorce culture appear? If we sort of look at the developments and consider, say, Betty Friedan, Shulamith Firestone, Ellen Levine, and these sort of people, that they were all involved in that 1950s and through to the 1960s, the late 1960s. They were all denouncing marriages. And I think Betty Friedan called it a caged hell and these sorts of things. And Shulamith Firestone referred to marriage and particularly procreation as the tapeworm of exploitation. There was a lot of activism around that time that Ronald Reagan signed the divorce laws in California. I think it was in the late 60s, and he's a Republican governor, of course. How did that come about? What were the movements that were, and we're talking ideology here, that were underwriting this move towards marriage as an oppressive institution, and if women can get out of marriage, or in any way they can get out of it, then it's somehow a social progress or represents social progress. And how did that come to be signed into law by a Republican governor, and then so quickly became law not only across the United States, but indeed internationally within a relatively short space of time? How do you see that beginning, and what was the ideological, intellectual sort of underwriting of those early movements, and why were they so successful so quickly?
Yes, it is amazing how it's swept through the entire Western world, and it's still expanding into other parts of the world. Well, it's a good question. Some of the aspects of it I think are familiar to us. The kind of cultural aspects of it, the sexual revolution, the Woodstock generation, the move towards sexual freedom and sexual license, preceded in some ways by the kind of Playboy generation of the 1950s. I think a lot of that's well known. Barbara Whitehead, in fact, wrote a book before mine, quite a few years before mine, called the Divorce Culture, and she outlined all this kind of thing, and the movement toward freedom and individualism and license, if you like. What I discovered though was an entire political dimension behind that, which I think is even more powerful. Some of it, like you say, was the political ideology of the '60s, the hippie and Woodstock generations, and then of course, the lawyers were involved in that too, and of course, there were pecuniary interests, and people have known that too. But what I really discovered was a much broader political dimension. One of the things that really surprised me was how the feminists had supplied the ideological engine that was driving all of this. The feminists were really the movers. The feminist bar associations were drafting no-fault divorce laws as early as the 1940s. And if you look around the world today, feminist groups are still pushing divorce on countries, especially in the global south. Now, they couldn't do anything for about 25 years until the late 1960s and 1970s, when most of the country, the United States, was looking the other way. People were our political attention was being diverted by the Vietnam War and by the civil rights movement domestically. And again, the '69 was the year of Woodstock and so forth. So the political culture was ripe for this law, which President Reagan, as you said, Governor Reagan signed in California, without really knowing, as he later admitted, without really knowing what it was all about. And many others, state legislatures followed in the United States, also without knowing what it was about. And then European countries followed shortly, and other countries followed shortly after that. Um, but there was the ideological driver of the feminists. There was also the extent to which the actual government machinery stood to profit by this, in which they got their noses in the trough very quickly. And by that I mean the courts, not just the lawyers, but the courts themselves, the judges, the forensic psychotherapists, the custody evaluators, a huge entourage of hangers-on around the courts, all of whom acquired both power and profit by by dissolving marriages involuntarily. And people they quickly saw that this was a gold mine of the power to just march into people's homes, um, sever their marriages, even if both parties didn't agree, involuntarily, and essentially plunder the household, plunder the family for everything it was worth. So it was, we didn't know what we were getting into. There was no debate on this at the time. There was no public discussion. There's been no public discussion ever since. At the time my book was published, and ever since, there's still been no public discussion about the politics or the larger ramifications of the divorce revolution. So that was why I wrote the book, was an attempt to show people, because there were at the time in the '60s and '70s, there were people that warned against this. They said this is madness. You cannot possibly allow judges and lawyers and government officials to tear apart people's marriages, to run people's private lives without them having done anything legal, without the litigants, the spouses, having done anything legally wrong. And they were correct. It was a huge, huge time bomb waiting to explode. And it didn't explode right away, but it's been exploding ever since.
Yes, in California, the communal law that back from the old sort of gold, claim days, or staking a claim, and the various participants who may want to claim as I understand it, and correct me if I'm wrong, the California's communal law system was in part at least affected by that, so that if 4 or 5 people were working a mine, they could claim equal shares. And now this communal ownership law was highly prized by the feminists, and they wanted to kick it off in California because they believed that would be the easiest gig. Now, this suggests a lot of organisation. This suggests money was going into it from somewhere. You can't keep flying back because most of the people that were agitating were from New York. So there are a lot of people moving around. There's hotel bills. There's all sorts of costs associated, and flying around was quite expensive back then. So there's a lot of costs associated, and be able to penetrate into the upper echelons of the senior committees in the state Congress and the Senates and the various public service administrations. This isn't something that just a bunch of radical feminists waving a placard in the street achieved. This takes a lot of organisation, a lot of setup, a lot of patient planning, a lot of money. Do you have a view on that? How are they able to reach those? I mean, we say that Reagan didn't really know what he was signing, and maybe with hindsight, he didn't fully understand the ramifications, but he was nonetheless surrounded by advisors that put that bit of paper in front of him. It had passed through the House, it had received the reviews, the various committees had signed off on it. It had even made it into the committees over a lot of other competing issues that would have been, at the time, you'd think far more important, yet somehow it came through. Would you have any thoughts on the organisation that was behind it and the funding? Where did that come from?
Well, you're certainly right that there's a massive organization today behind it, running it, defending it. One of the striking things I found was that in the United States, throughout the divorce law, family law is generally handled ostensibly, at least by state governments, state legislatures. And I quickly found that in virtually every state house in America, all 50 of them, the committees that the legislative committees that appoint and promote judges are almost all controlled by bar associations. In other words, the bar associations make it a point to get their members elected to the state legislatures, almost for the purpose, the single most important purpose being to get control of the judicial committees, the committees that appoint and promote judges. So the judges are really the puppets in many ways, or the prisoners, if you like, of the bar associations, who can control their appointment, reappointment, and their promotion. And so it's really the judges they're required essentially to funnel money from litigants to the lawyers, to the bar associations, to whom they are answerable. So the organization is huge, and it's very it's riddled with conflicts of interest all the way through. Now, whether this organization developed beforehand and was responsible for this, or developed afterwards and simply was filling the void that was created by these laws, I can't really say. I tend not to believe in the kind of conspiracy view of things. I tend not to believe that this was all engineered. I think that many people genuinely didn't know what they were doing. There have been a number of suits in some state houses, like Texas, for example, where it was pretty plausibly shown that the state legislature was hoodwinked. They were told that no-fault divorce was essentially divorce by mutual consent. That if people were, that it provided for people to be allowed to divorce if they both agreed, and to do so without, elaborate procedures. Many of them, I think, genuinely did not realize that what they were creating was unilateral divorce, and involuntary divorce that was often over the objection of at least one spouse, occasionally, sometimes even both spouses. And and I think I tend to feel that the machinery and the pecuniary interests then got their noses into the trough, that they then filled the void, that we basically opened the floodgates to let them into the private family, and they've simply occupied it. Now there were other circumstances that allowed this. One of them I've also found, I don't write about this in the book, but I've written about it since, is that the church had shockingly vacated this territory. In other words, in the past, when a marriage was in trouble, when people were disagreeing, or you had conflict in the home, the church or the local community or both tended to offer, or the extended family tended to offer counseling, help, support, sometimes, criticism. Um, and again, the culture made this, you know, started frowning upon this. So the churches basically vacated the ground of the family and stopped acting as the advisors or the helpers or the psychotherapists. And when this church vacated this turf, it was filled by government officials, lawyers, judges, forensic psychotherapists, and so forth. So there was a number of factors working together, both cultural, ideological, and pecuniary, all, um, I don't want to say conspiring, but acting in logical ways once we just, you know, once we forfeited the wisdom of the ages.
I've noticed in jurisdictions where judges are not re-elected or reappointed, but where they're appointed for either long periods of time or in some jurisdictions appointed for life,
Mm-hmm.
so they're well protected. They've got a job for as long as they want it, and I won't mention the jurisdictions, but even in those jurisdictions, they're just as active, as far as I can tell, just as active, I believe, in funneling benefits and work to that clique of you mentioned the hangers-on around the divorce system. They're just as active in putting benefits their way. So they seem to be just as ardent and fervent in their pursuit of what some may say are feminist ideological objectives, regardless whether they face an election at the end of the year or the end of a term, or whether they've got a job for life. And that rather surprised me. But is it something you've noticed as well in your examination of the issues?
Yes, yes. Just so your listeners know, in many American states, judges are elected rather than appointed, and in theory, that should provide citizens with the opportunity to, keep an eye on the judges and potentially develop campaigns against those that are, that are dishonest or unethical, and remove them at the next election. But as you say, in practice, it's almost never works that way. They have various ways of the bar associations have various ways of ensuring the reelection of the judges they like. Most Americans, like most people, don't pay a lot of attention to local government elections, and even less so judiciary elections. It's just not something most of us have on our radar screen or put energy into. So in practice, the election of judges doesn't serve as a very effective way of making them accountable to the citizens.
In the United States, given the tort law issues and so on, there's certainly an attitude or a view held by many, as far as I can tell, that control of the judiciary means, in effect, it's tantamount to controlling legislation, either in initiating legislation from the bench that it's claimed activist judges and jurors do, or the ability to strike down legislation that may displease certain sections of the community. And that seems to be a much bigger issue in the United States than it is in other jurisdictions such as the United Kingdom or Australia and Canada. But the idea of putting activists or people with strident viewpoints in a position of being a jurist and presiding over cases seems to be more or less accepted. And the idea, if we can't get our people in there, that the other guys are going to get their people in there, and that creates, as we saw during the appointment of Justice Brett Kavanaugh, that certainly creates some animus on all sides as they try and face each other down. Just on the early days of the concepts of divorce law and child support in particular. So starting to move on a little bit now from the actual divorce itself or the precise legislation around it, the dissolution of the marriage, onto the subsequent financial consequences, which is, some may say, where the sting in the tail comes, seizing someone's house and assets, seizing their future income for in some cases up to 30 years into the future. These can have huge ramifications for people caught up in that. In the early days of the Soviet system, after the Bolsheviks had come to power, they were determined to move people from the rural areas into the cities to fill roles in factories and industry generally. And they found that when they separated
the men from the village, that they weren't necessarily sending money back to the village and this sort of thing, and the villagers that were getting squeezed to give up their income through seizures of crops and harvests and the like. So the Bolsheviks came up with the idea of paying child support and sending it back. So it was rather a system designed to be built around massive social engineering, and this is something that seemed to become very apparent in that early Bolshevik planning. Is this something that you've observed and considered in any way in your own work and study?
Well, yes, it is interesting. I mean, the parallels between what's going on here in the in the United States and the Western world since the 1970s is very interesting, because the only other regimes that I know of that have ever experimented with what we now call no-fault divorce were the Bolsheviks, as you said, in the 20s, and the Jacobins in the French Revolution. So, revolutionary, Jacobin France, Bolshevik Russia, and California. These are the three places where no-fault divorce has been hatched. And the Bolsheviks had the sense to repeal it at one point. They saw that it was creating havoc in the Soviet society in the 1920s, and they eventually said no more. We haven't had a similar kind of realization, maybe because it came more gradually, like the proverbial frog in the kettle. But no, it's quite striking the kind of bedfellows and in fact, Barbara Whitehead also says that in the early from the early years of the American Revolution, divorce was something that people began growing, and people began taking an interest in. So there's clearly a parallel between the sexual revolution, especially the divorce aspect of it, and the political revolutions. And in fact, if you look at the major revolutions of modern history, the English, the French, the Russian, the Chinese, they're almost all accompanied by sexual radicalism at the same time. If I could just go back to your earlier point about this, the United States and the growth of judicial power here. This is something that's very important, and something I've really kind of discovered during and after I wrote the book, was how what's going on in the divorce judiciaries is really, in the United States especially, is really the vanguard of what's going on in the judiciaries generally. And the United States, the extreme judicial power that is exercised, political power that's exercised by the judiciary in the United States, is also only the vanguard of what's been going on, I think, throughout the Anglophone countries, at least, and increasingly European countries as well. And that is what the late Robert Bork called the worldwide rule of judges. Judicial power seems to be increasing everywhere. The United States is the vanguard, and the family courts are the vanguard of that. Now, conservatives here in the U.S. and increasingly in Britain, you hear this term, judicial activism, is being used. In Canada, I don't know where else it's being used, but certainly today we're seeing one of the major controversies today between the European Union and its dissident countries, not only Britain but Poland and Hungary, and Romania more recently, have involved the use of judicial power and the attempts of the Polish and Hungarian governments to rein in the power of the judiciary. So this is growing everywhere, and conservatives especially have been alert to this. They've been using these terms for years now, like judicial activism, and ruling about and warning about the undemocratic power of judges. But it's strangely strange that those same conservatives are silent about the power, the sector of the judiciary where this is most extreme, and that is the family court judiciary. Conservatives here in the U.S. are almost completely silent. The conservative media is as much of a news blackout there as there is in the liberal media about the abuses that go on in family court. And this is very peculiar because every aspect of judicial activism that you see in the larger judiciary is almost certainly preceded by more extreme versions within the family court judiciary.
You mentioned the camp followers and the gaggle of hangers-on around the divorce law. Just looking at some of the divorce law jurisdictions around the world, and just having and it doesn't take much effort or time, but looking at and I'm looking now at one judge who was a street activist for feminist issues, a placard waving street activist, and was appointed as a judge. Now, no one who's in any elected representative who's sworn to uphold the Constitution. Many would argue, I would say, that if that attorney general, state attorney general, or federal attorney general, whoever it was, who would appoint such a jurist, knowing their activism and knowing their strident ideological doctrinaire views, anyone appointing such a jurist is in fact acting and very much so acting against the Constitution. They're in fact breaching the Constitution, and yet they do so knowingly, and they must be premeditating it. It can't be an accident given the amount of times it's happening. So I see this, but also just moving even past the senior jurists to the more junior jurists that may just handle directions hearings and more basic paperwork and things like that. But still have quite an influence on proceedings. Just looking at them, many of them also are very strident activists, and they're many gender studies degrees. In fact, a lot of courts, divorce courts, declare in their adverts that they insist that the applicants to various positions within the legal system must have a gender studies degree, and these people have their theses posted online, or they're accessible at least, and where they've got the most strident anti-male, anti-heterosexual male views and anti-white male views, and almost to the point where it's no longer doctrinaire, it's simply hysterical nonsense. And yet these people are hired, not only hired, but preferred into the court system. Similarly, you mentioned psychotherapists. Having a look at them, there's a lot of them that, and there's a list of 50 preferred psychotherapists at one, or family counsellors and family advisors, as they sometimes call them. There's lists of them that the court hands out, and they insist that any work is handed to one of these people. And again, a cursory glance can see that these people are not simply low-level activists or people that may hold certain views. They are at the absolute vanguard of social engineering and change, and yet here they are in the courts advising and assisting, or corrupting in some cases, some may say, the final judicial decision. Now, this seems to be not only accepted but desired. Is this something you've also noted?
Yes, I do describe some of that in my book. In fact, it's one of these many aspects of my book could very well engender entire books of their own, and that's one of them. I would hope that scholars out there, I was hoping that scholars out there, potential scholars, younger ones, would take up various aspects of what's in the book and write entire books on some aspects of it, and that's certainly one of them. Yes, the judiciaries are full of political activists, and this is another area where conservatives are often harbor dangerous illusions, because they think that gender studies degrees, of which there are many, are useless. They think that that these women and others get gender studies degrees, women's studies, queer studies, and that there's nothing they can practically do with them. Well, that's simply not true. As you say, they populate the social work industry. That's the main place they use these degrees, is social work and the judiciary, the family law judiciary especially. I show that in the U.S., much of family law is governed. If you enter a family court, you don't even get a judge. You get a lawyer wearing a black robe with a title like a judge surrogate, or something like that, who is not really a judge, who's not required to be approved by the legislature, by the separation of powers. And that judge could very easily be a political activist. That judge could very easily be lobbying in favor of the legislation that he or she then adjudicates, which is a flagrant violation of our separation of powers. And there's many, many examples of this. In fact, many other violations of the separation of powers and the independence of the judiciary in the family court system. So you're absolutely right about that.
Just on the issue of then compensation law that's crept into family law, this idea that, and I'm thinking of one case now, and I'll just sort of give an overview. the wife chose to change her lifestyle to a lesbian lifestyle, and there were 2 children, and so she filed for divorce so she could be with her new partner. And the way and I had some involvement in this, the way the court decided was because she was adopting such a lifestyle, she'd have no man to look after her, so effectively she needed more of the marital assets to compensate her for her own life decisions. Now, so she was able to get close to 80% of the assets from the marriage, and of course generous child support and alimony, and the husband was an executive on a reasonable income. So, but nonetheless, he was financially pretty much ruined by this. In addition, the court arbitrarily decided that one of the children had special needs and would require financial support effectively forever, and so that this gentleman was paying out until, or would pay out until his death, one presumes. So, but these things appear to be rather arbitrary. They don't appear to be strict guidelines that prevent or limit judicial overreach in these things. And it's the idea of compensation law that you were brought here as a slave 500 years ago, therefore, or your ancestors were. These sorts of concepts around compensation and so on seem to permeate a lot of the people. And a lot of the people that would be on the street sort of waving about, carrying on about, say, racial issues, may be the very same people who would be on the street about feminist issues. So there's a lot of interchanging. And just on that compensation side generally, and its underwriting concepts and ideology, there's also the issue where a lot of the people who are within the industry all know each other and in many cases are intimately involved. So we have a situation where the psychotherapist may be the intimate partner of the woman who's also, say, doing some other aspect of the system. So they're all passing cases around to each other, but the litigants don't know about this. So people who have, and you come back to your conflict of interest point, people who have a huge conflict of interest in as much as they're involved in intimate relationship, but they aren't declaring it, and they're moving cases around between them, each confirming the other's claim that the father is an abuser, or he's this or that, or should pay more, or those sorts of things. This is a substrata that, as far as I can tell, appears to be hidden. Is this something you've noticed also?
Oh, yes, absolutely. I mean, my book has many horror stories like that, and especially when it comes to the area of child support. And in practice, there's virtually no limits on the amount of money that can be ordered in child support or maintenance payments. There's no limits to the rationalizations that can be conjured up to justify them either. I mean, as you say, just absurdities. I call it absurdistan, and others do too. As in Eastern Europe under the communist system, just people forced to pay, as you say, 80% of their income, or sometimes 100% of their income, or even more, is rationalized. And so effectively, the father is plundered for everything he has and criminalized, because you obviously can't pay this. You can't pay 100% of your income and still expect to eat or pay your rent. So it's effectively a system of summary plunder and summary incarceration. People are turned into criminals, bankrupts and criminals, in ways that they are completely powerless to control, and without having ever committed any legal infraction in the first place. So it is unbelievable. I mean, it is. Some people describe the whole thing, and I think with some justice, as a system of organized crime. I mean, the gangsters are the ones sitting on the bench, wearing the robes of judges, and the innocent people are being put into the jails. And I don't think there's any possible. It's not possible to refute this. It's quite plainly what's happening.
This again, just for listeners, Professor Baskerville's book, Taken into Custody, The War Against Fatherhood, Marriage and Family, an absolute must read. And again, the link will be below. And there's some excellent reviews on Amazon as well, many 5-star reviews there that you can also refer to. Professor Baskerville, just in sort of summing up or wrapping up, I think we can agree that there's a lot of remedial work that could be done in this area in terms of improved levels of justice and so on. But if you were to sort of give your main points as to what reforms may be needed or should be implemented to improve the system, what would be your priorities in terms of making the system better?
Well, the legal mechanisms that are needed to reform the system are actually fairly straightforward and simple. I'm not to say that they would be easy, because they would meet fierce political resistance, but it doesn't require a lot of social engineering. The traditions of the provisions of the United States Constitution, and by extension the provisions of the English common law, which govern most of the English-speaking countries in the world, and some others as well, would solve this problem quite straightforwardly. There's basically two traditional bonds that need to be guaranteed. One, you need to guarantee the bond, the marriage bond. Marriage needs to be a legally enforceable contract. It's not to say people can't get out of it. It's not to say people can't divorce. But those who break the contract, either by unilateral divorce or by adultery or violence or whatever, need to be held accountable and accept the consequences for breaking a contract. It needs to be a legally binding contract. Whether you regard it as a religious covenant is, in a sense, secondary. Whether you do or whether you don't, at least it has to be a secular, legally binding contract. So that's one bond that has to be guaranteed by the state. The second bond that has to be guaranteed by the state is the parent-child bond. Nobody should be allowed, no official should be allowed to take away someone's children without showing that they've done something quite seriously and legally wrong. And again, if you look at the case law, not only in the United States, but in England and in, I think, all of the English-speaking countries and in the common law, the parent-child bond is treated as inviolable and more or less sacred. You can only take away somebody's children traditionally by showing that they've done something very serious and legally recognized as wrongdoing, child abuse at the very least. So these things simply need to be enforced: the parent-child bond and the marriage bond. And if you guarantee these, again, it doesn't mean that they won't be broken, but they need the sanction of the law if they are broken. Now, other provisions you can add on, things like shared parenting laws, for example, or laws, adjusting, making sure child support is reasonable and fair. These things can be done also, but they're ancillary. They should be the basic principles are there in our system of common law, and they simply need to be enforced.
Okay. What about things like burden of proof in the actual process, judicial process and decision-making process?
Absolutely.
The child support agencies, for example, seem to have no, as far as I can tell, no requirement to meet a burden of proof before they reach an administrative judgment, which can be quite punitive, the judgment. Similarly, in the cases, certainly that I've seen, the burden of proof that the man, typically, that the heterosexual male has to meet is a great deal higher than the burden of proof that other parties, including professional contributors, psychotherapists alike, there's a very low burden of proof requirement there. So the actual precise judicial process itself, do you think that could do with some tightening up?
Absolutely. There again, I think simply enforcing our traditional standards. As you say, child support here in the U.S. and in Canada, men are routinely jailed without trial, an obvious violation of human rights that the human rights organizations simply ignore. And the really egregious examples are the cases of so-called alleged domestic violence and child abuse, neither of which are adjudicated as violent crimes. In other words, child abuse accusations against either parent and domestic violence accusations, usually against the man or father, are generally not adjudicated as crimes. The man usually doesn't. The accused usually don't spend huge amounts of time in prison. They're simply thrown out of their homes summarily and kept away from their children in order to affect the custody situation, to create a status quo ante. Instead, and reputable scholars have proposed this in the case of child abuse accusations, and I propose the same thing in the case of domestic violence. An accused criminal should be tried according to the standard rules of evidence. If he is convicted, he should be jailed or punished, and if he is acquitted, he should be left in peace in his own home with his own children. But instead, we've created this gray area where there's no due process of law, no possibility of clearing your name. You're simply thrown out of your home, taken away from your children, and treated as if you're a criminal without any burden of proof. This is obviously intolerable in a free society. The other corollary that's intolerable as well is that it's standard in most people's understanding that knowingly false criminal accusations, such as accusations of child abuse or domestic violence, knowingly false criminal accusations of these things are crimes themselves and should be punished as crimes. And yet they almost never are in the family courts. So, I think most people would be shocked at seeing in my book and in my subsequent book how much of what they assume to be the case in the law, due process protections and the constitutional protections that we think we have in the English common law and in the American Constitution are simply ignored.
Okay, so we lost the Skype connection at this point, but it was only a few minutes before the interview was meant to conclude anyway, so we lost maybe a short paragraph, but fear not. Professor Baskerville has already very kindly agreed to come back and discuss his latest book, so look out for that video interview in the coming days. Look forward to your comments below on this interview, and we hope to provide you with many more in the coming weeks and months. You've been with Tacitus Today and Professor Stephen Baskerville, and thank you for watching.